After weeks of testimony in the penalty phase of a first-degree murder trial, the jury has reached a decision for the 4 defendants. The clerk begins by reading the verdict for Isaiah Chance. The defense attorney for Rashad Murphy delivers what he considers the most important mitigating factor, contrasting it sharply with the severity of the current charges. The defense for Davion Murphy introduces crucial medical evidence, arguing that his actions were influenced by a documented brain injury. The focus now shifts to defendant Davion Murphy, whose attorney paints a grim picture of the violent, unstable world he grew up in. Concluding her argument for Sean Gathright, his attorney makes an emotional appeal to the jury's sense of justice and humanity. After recommending life sentences for the first 3 defendants, the jury's final decision for Davion Murphy is announced. With the verdicts delivered, the judge offers a heartfelt and emotional thank you to the jurors for their service in a uniquely challenging and high-stakes trial. Before the jury begins deliberations, the judge gives them their final instructions, explaining the profound moral responsibility they hold. The defense presents expert testimony to explain Isaiah Chance's cognitive limitations, arguing they played a significant role in his actions. If you enjoy our trial coverage, make sure to like and subscribe for daily courtroom updates. All right, let's get to it. After weeks of testimony in the penalty phase of a first-degree murder trial, the jury has reached a decision for the 4 defendants. The clerk begins by reading the verdict for Isaiah Chance.
Isaiah Chance should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May 2026 in Hillsborough County, Florida, Miss C.S., foreperson of the jury. Defendant Sean Gathright, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright committed the homicide.
With the penalty phase underway, the defense attorneys for the 4 convicted men begin their closing arguments, each making a final plea to the jury to spare their client's life. First up is the attorney for 18-year-old Sean Gathright.
There was a lot of numbers, scales, questions posed to you over and over, and I told you at that time I wasn't going to hold you to those numbers. Some of us said we didn't really like the numbers. It was just kind of getting a feel for where you guys stand coming into a new scenario. And the reason I said that was because this isn't a test. This isn't a numbers game, not a math problem or an equation. This is most literally a life or death.
The defense builds a case for Sean Gathwright's character, arguing that his actions and demeanor prove he is not the evil person the state has portrayed.
You heard that he's still asking about other people when he talks to them, trying to keep them in good spirits while he's sitting in jail. While he is facing a death sentence, he's worried about other people. That's not wicked. That's not evil. The theme from those witnesses on Mr. Gathwright's behalf was he was positive, he was funny, he was witty, he made people feel good. You heard that he was kind and respectful and well-mannered. And you don't just have to take the word of family and friends that know him and, of course, want to come in and they want to save him, they want to help him. You saw it from Mr. Gathright. That young man had the courage to get up there and face you and talk to you.
The prosecution has painted Sean Gathright as a mature, calculated orchestrator, but his attorney counters by focusing on his youth and impressionability at the time of the crime.
Maturity on the outside is not the same thing as being a developed adult and having life experiences, having knowledge, having street smarts. It's not the same thing. You can be well-spoken and smart and mature and still make really bad decisions. He is impressionable. He's naive. He was curious. He told you he was easily influenced.
Concluding her argument for Sean Gathright, his attorney makes an emotional appeal to the jury's sense of justice and humanity.
Vote for life does not excuse any criminal behavior. It's not an excuse. It doesn't excuse responsibility for a crime. A vote for life doesn't diminish the life of Charles Jones or the loss to his family or his loved ones. A vote for life in this case is the just decision. It's the right decision for Mr. Gathright. Do not define Sean Gathright by the worst decision, the worst moment of his life. Sean Gathright is a son who's worth saving. He's a friend worth saving. He's a nephew, worth saving. He's a grandson that's worth saving. He's a baby brother, worth saving. He's an uncle, worth saving. I'm asking you to do just that. Thank you.
All right, thank you. Mr. Petridis, on behalf of Isaiah Chance.
Thank you. Please, the court. I want to thank you again.
Next, the attorney for defendant Isaiah Chance addresses the jury, immediately focusing on the core issue of life versus death.
You're going to get a lot of thank yous today, and they're well deserved. We are at the end of your service, but as I said in my opening, we are also probably at the most difficult part of your service, and we all understand that. I want to start by saying justice will be served. Isaiah Chance will spend the rest of his life in prison, punished away from society. All we are asking is that you spare his life. Death is never required.
To illustrate Isaiah Chance's character and strong family bonds, his attorney shares a poignant detail about his relationship with his father.
He told you something else. He said that Isaiah called him all the time. And every time he hung up the phone, he said the same thing beforehand. He said, "I love you," to his dad. Every single time.
The defense presents expert testimony to explain Isaiah Chance's cognitive limitations, arguing they played a significant role in his actions.
Let's talk about what she said when she noticed him. He was quiet. He was mild-mannered. He wanted to be there. He wanted to do the test. He was not depressed. And he kept saying the same thing essentially throughout the testing. I'm smart. I know I didn't do great in school, but he wanted to impress her. And he used some big words, and I would say he used some correctly and some incorrectly, like he did with Dr. Warner. He got a full-scale IQ of 71. That's what she got through the testing.
The defense highlights Isaiah Chance's role as a father, asking the jury to consider the impact of their decision on his children.
Letter to ask him a question only he can answer. And he will be in prison. But a father can still be a father behind bars. A letter, a phone call, a presence. We are simply asking for you to leave that door open. 7 people testified in the penalty phase. 6 who have known him parts or all of his life, and a doctor. Dr. Hardy told you the clinical side. People like Isaiah are a little more vulnerable. They want to belong. They want to follow because it's safer than the alternative.
The focus now shifts to defendant Davion Murphy, whose attorney paints a grim picture of the violent, unstable world he grew up in.
He grew up in East Jacksonville. Davion Murphy wasn't born into a life of privilege and opportunity. He was born into violence and instability. What chance did he have? And folks,
the defense for Davion Murphy introduces crucial medical evidence, arguing that his actions were influenced by a documented brain injury.
The objection.
These scans were done to show you that Davion Murphy suffers brain damage. What does Dr. Rubino have to come in here to risk his medical license to say, and you saw the scans, and you can take it back if you want to look at them, to say that he suffers from brain damage? And the state had its radiologist, a diagnostic radiologist, of whom I respect, Dr. Glickstein, I respect, but he doesn't have the knowledge and the upkeep of the new technologies. He wasn't able to, he hasn't seen he said, I think it was like once an MRI, DTI, which is commonly done in these radiology facilities. Why would a neuropsychologist recommend scans that a neurologist send to a radiologist?
Finally, the defense for Rashad Murphy presents its case, focusing on the deep psychological scars left by his traumatic upbringing.
The diagnosis by Dr. Collins is that Mr. Murphy, suffers from post-traumatic stress disorder, PTSD. And as you know, it's a mental condition triggered by experiencing and or witnessing terrifying events. And it disrupts daily life. It affects his judgment, his decision-making as an adult.
The defense attorney for Rashad Murphy delivers what he considers the most important mitigating factor, contrasting it sharply with the severity of the current charges.
And I ask you, when you decide on your vote, compare that fact, that stipulation.
Before the jury begins deliberations, the judge gives them their final instructions, explaining the profound moral responsibility they hold.
The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the result of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that a defendant should be sentenced to death.
After recommending life sentences for the first 3 defendants, the jury's final decision for Davion Murphy is announced.
We, the jury, find Davion Murphy should be sentenced to life in prison without the possibility of parole. Stated this 15th day of May.
With the verdicts delivered, the judge offers a heartfelt and emotional thank you to the jurors for their service in a uniquely challenging and high-stakes trial.
These are tough cases. These are tough cases. And I've handled a lot of tough cases. This is my first rodeo as far as handling tough cases. This one takes the cake. This one was one of the up to date, in my 24 years of doing this as a judge, one of the toughest cases. And you all are amazing. You're amazing people. You are smart, you are attentive, you are patient, and you are just. You're just. And I just want, on behalf of everyone involved, not just the parties, the attorneys, myself, our entire community owes you a debt of gratitude. And I wish I could do something more for you other than just say how amazing you are. I did have the bailiff give you all just a small medallion. It's just a token. I wish there was more that I could do, but that is all I can do.